Hello again, this is Ben Hitchcock Cross talking to you today about Judge Stephanie Brown's decision in the Garcia-Hoven case versus MPS to decide that you couldn't talk about Jerimiah Holiday within weeks of first getting the case. So here she decided because Dr. Holiday was apparently not named in the complaint. Again, this is the same Dr. Holiday whose wife worked at DPI and who the ERD could not find his ERD complaint when Debbie Keitha asked for it, who's the bad actor in Debbie Keitha's case, Dr. Ford's case, and also to a certain extent in Dr. Garcia-Hoven's case. And what's going on here? Of course, they promoted him. MPS did. Of course, they did. But ALJ Brown is trying to exclude any mention of Dr. Holiday at the beginning. Okay? So she apparently made some ruling on that, saying that we could know, it says discovery on Dr. Holiday shall not be had. Okay. So let's look at what the rule is here. So, and the reason this is why this is going to come to bite her back in the butt, I think, is going to be clear when we read this ruling. I'm sorry it's so small here, but that's how we're doing it. ALJ shocks ruling excluding evidence. So this is a case I've brought up a couple of times. This is Burton here, and one of the things that's going, and I've been silenced. Usually Alice DeLau overtalks me. Sometimes she mutes me when I bring this case up, because what happened was ALJ DeLau just decided that this case was not good and dismissed it not once but twice. Lurk sent it back not once but twice, and then the second time said don't give it to Alice DeLau. So they gave it to Judge Schacht. Judge Schacht then deferred to Alice DeLau and incorporated every one of her rulings, and now Lurk's saying you can't do that either. And they're explaining why making a decision on discovery without hearing any evidence of any of the parties is not only improper but evidence of bias, which then requires the ALJ to remove themselves, which of course we asked Stephanie Brown to do, but she refused. Said we could go to Lurk if we had a problem with it. Okay, so at the very beginning of the hearing, even before he had received into evidence ALJ DeLau's July 2nd, 2007 decision on remand from Lurk, ALJ Schacht ruled on his own initiative that, quote, anything that occurred after the submission of the withdrawal is not relevant, and I will not go into anything subsequent to that. And boy, do I get that kind of ruling all the time. So the reason we're bringing this up today is MPS is asking the judge in Teresa Folaron's case to not allow us to discuss about anything that occurred 300 days. Of course, there's so many cases on this, but we'll see what the ALJ does, because of course they just do whatever they want apparently, and then come back and say Lurk can clean it up afterwards. Because that's very clearly what Stephanie Brown told us. So, Burton expressed his disagreement with this. ALJ Schacht then spoke about and reiterated on this ruling at some length. They're going to throw some shade here. In the course of his ruminations, ALJ Schacht expressed the view that nothing that occurred after the filing of a withdrawal could be relevant because of the ERD's administrative rule, which requires the dismissal of complaints when a withdrawal was filed. He also repeatedly expressed the opinion that the Commission had no legal authority to come to any other conclusion about the effect of withdrawal. After some extended explication of his views, again, some shade here, the ALJ also ruled that he would not allow Burton to go into his beliefs or state of mind or understanding about the consequences of the withdrawal or what he could do after it. This apparently would apply to beliefs Burton held at any time, even before he submitted the complete withdrawal request. Right. Of course it would. So that's the problem. We call these a priori discovery rulings. So before you have any evidence about what's going on, you're making a categorical decision, cutting off discovery right here. Anything after this date is cool. Anything before this date is not cool. We'll see how that works out. The Commission concluded that the ALJ's rulings that he would exclude any evidence about the events occurring after the cutoff point he established based on a lack of relevance, and that he would allow no evidence about the events occurring before this time, which might have had an impact on Burton's understanding of the effect of settlement or withdrawal, were erroneous and created a significant appearance of unfairness which was so high as to be intolerable. That means you should have removed yourself because it looks like you've made a decision before you have the evidence. And that's not what a judge does. It's not the minimum required of being a judge is to hear the evidence first, make a decision on that evidence, and then base your decision on the facts in a law in such a way that both parties can understand it. One reason the Commission reaches this conclusion is its disagreement with the ALJ on the issue, the relevance issue itself. Evidence is relevant if it has any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. I just want to be clear, in the quote that we're going to use from Stephanie Brown, I brought this up, I probably read it 10 times. She told me I was having a standing objection, I didn't need to use the word Burton anymore. It appears that the facts of the case include the fact that on May 25th, the parties entered into a written agreement. Okay, and we'll get into facts. This question, all right. Here we go. Similarly, the question of what Burton might have believed about the effective settlement or withdrawal and what he may have caused such beliefs may not ultimately be conclusive, but are surely of sufficient potential relevance that preemptively excluding them in this kind of categorical fashion is unreasonable. The ALJs were this type of excessively restricted and heavy-handed ones, which the Commission has previously cautioned. That's another favorite of mine is Fautek, and Roberge is another great one. Fautek is a great case. Okay? So again, when I bring this up to ALJ Delau, she overtalks me or mutes me. She then lets me make my offer of proof, but she overtalks me because I apparently mentioning her involvement in this case is not something that she prefers, which, I understand. Okay. So let's go here and look what we have here. There we go. All right. So this is from, I believe, day 2 of the Garcia-Hoven hearing, and we're talking to Angela Ford, and guess what? Dr. Holiday comes up because he's related to the case. That's what happened. So I just want to highlight this here. This is Mr. Reardon, the attorney for Milwaukee Public Schools, is going to object because my line of questioning is raising, let's say, Dr. Holiday comes up here. So this is exactly what the point is. I'm asking the witness a question about who did what here. It doesn't matter, and so it turns out that Dr. Holiday did something bad, apparently, according to Dr. Ford. Well, if you followed Stephanie Brown's ruling there, which again I think is ambiguous enough to I think save at least I would say it makes it unclear as to what extent that she is saying that discovery into that can't be had, meaning are we allowed to ask a question about Dr. Holiday, or what happens if Dr. Holiday is raised and comes up like that. MPS's contention was if the answer involved Dr. Holiday, you had to shut up. Shut up. They told their witnesses several times, don't even mention it. We had that happen. They didn't tell us that was going on. But they didn't mention to us that Dr. Holiday was in the answer, so they just didn't put it in there. Well, when it turned out Dr. Ford, they couldn't control her, we found out that, yep, Dr. Holiday was all in there. So, that's what's happening here. It turns out that Dr. Holiday is relevant. Now, I think we're going to see some, we're going to call this, and this is why we want to look into this is normative here. There's going to be some pressure on yours truly to just go along with the flow. Mr. Reardon, I'm just going to object at this point in time. This letter is dated January 21st, 2020, which is beyond this period of time. That's fine, says ALJ Brown. I'll let the questioning continue. Go ahead. Yours truly says, can we get the grounds for that decision, please? So this is the first time that I'm basically told to shut up here, but we'll see what happens. ALJ Brown says you can the question, go ahead. I'm letting the questioning continue. Well, I appreciate that, but nevertheless I want to know on what grounds. So I say, on what grounds, please? here's where sort of the normative aspect comes in, because I guess I'm getting coached here by Mr. Reardon to just told to shut up here and just ask my question. Mr. Reardon says she's letting you continue to question. Appreciate that. Thank you very much. But I say no. On what grounds is this being overruled? And so Mr. Reardon, not the judge, says it's not being overruled. Oh, but the judge comes in and says it's not being overruled. I said you could continue. It kind of feels like they're both working together to hide this fact here. What are the grounds? Why are you making this decision? Let's get that on the record. ALJ Brown, it's not being overruled. I said you can continue. She's allowing you to question, says Mr. Reardon. Just shut up and ask the question and move on. That's the message I'm getting here. So, that's a bit of pressure, I admit to it, and it seems like I'm about to succumb. Thank you, I say, and then I ask a question. So do you see who? But I catch myself. It's what I see. I don't have a recollection, but we'll see. So I say, well, no. So this is Mr. Reardon, made an objection. Mr. Reardon apparently is, participating here. And she overruled it. That's what Mr. Reardon says. And I say, appreciate that. Exactly. So I'm asking, what are the grounds for the overruling? And ALJ Brown says, can we just move on? This is, again, normative pressure here. Be quiet and just ask your question. We don't want to say what the reason is. Again, I'm feeling here, sitting here today, that ALJ Brown and Mr. Reardon are putting the same kind of pressure on me to, again, shut up and move on. But hey, I say we can just move on, but I'd like to get for the record and for the sake of due process what the grounds are for that ruling. And I got to be clear here, because this I distinctly remember. There is about 30 seconds of ALJ Brown staring me down here. She is staring me down before she says, I'm finding it's relevant. Is that what you want to hear? She's talking about Jerimiah Holiday. And again, it's the statement here that troubles me the most, is when she says, is that what you want to hear? Because I think they all know at the beginning what I want to hear, which is the grounds for her decision, and she's not giving them to me. We'll see how many times. So she says once, can we move on? Twice, 3 times, 4 times. Mr. Reardon says once, twice, 3 times, 4 times. Okay, so then she says, she, remonstrates with me because I'm not being Wisconsin nice or something like that. I don't know. But she says, I would appreciate it if when I make a ruling, you just continue. So you made a comment before about how this is Mr. Reardon, is making objections. He's making speaking objections, which are telling the witness what to say or not to say. That's different from me saying, I'd like to get your grounds for your decision, Judge, on the record, because remember, that's what judges do. They hear from both sides. They decide based on the facts and the law, and they write decisions that both sides can understand. That are decisions, by the way, that are supported by the facts and the law. That's evidence of sifting and winnowing. That's what due process requires. So, again, she says, I guess for the 5th time, now let's continue. But again, somebody's got to stick up for the Constitution and the employee. And I say, well, again, for the sake of due process, we have both the right and you have the obligation to put the reasons for decisions on the record. We asked for that to happen, and I think we'll continue to do that. And then I asked my question. So, that there is my story about, I guess, my sort of explanation of how, what happens when you make decisions about evidence before you actually hear the evidence, decisions on discovery before you hear the evidence. And guess what? Stephanie Brown didn't need to figure this out by trial and error, because there's a decision going back to at least 2007 that explains it in precise detail. And guess what? We gave it to her not once, but probably 4 times before this hearing. So, stick with us. We'll keep you informed. Have a great day.